We'll hear from the appellant when you're ready. I'm sorry, pull that back over in front of you. If you want to push it down some, that's okay. But as I should have mentioned earlier, of course, this is going out on YouTube, and there will be a recording of it on YouTube. So whatever we say here is for posterity, excuse me. Go ahead.
Hopefully for prosperity, too.
Yes.
May it please the court, Your Honors, my name is Bill Lockett. I'm here for the appellant, Mr. Lonnie Harris. This appeal raises two questions. First, did the trial court...
do you want to reserve any time for rebuttal?
If I have any, Your Honor, I'd like to reserve 2 minutes.
Pick some now. 2 minutes. 2 minutes, that'll be fine.
Yes.
Yes.
Thank you, Your Honor.
That's fine.
The first issue is, did the trial court apply the factors set forth in TCA 36-4-121 to arrive at an equitable division of marital property? And second, did the trial court so verbally and emotionally abuse the appellant to the point that the fairness of the trial has been called into question? To answer the first question, Your Honor, I'd like to look at the facts of this case and apply them to the factors that are set forth in the statute, and come back to that second issue later. But before beginning that analysis, Your Honors, let me quickly outline what appellant believes should be the appropriate division of marital property in this case. It was stipulated at trial that the total contributory increase in value of what is referred to in my brief and in the transcript as the Callahan Road property, that total increase in value, contributory increase in value, was $417,000. Therefore, Ms. Harris's half of the increase is $208,500. Now, also during the pendency of this case, Your Honors, pursuant to Chancellor Moyer's order, Mr. Harris paid Ms. Harris $152,500 in cash. And finally, Ms. Harris, it was found, dissipated assets.
Why did he give that money to her?
Your Honor, quite frankly, I'm at a loss as to why he gave it to her. Now, let me concede, I did not represent Mr. Harris at trial. He was proceeding pro se in both hearings. I've only represented him on appeal in this case. I can say that the court ordered that award prior to the first appeal in this case. There was an appeal. It was successful, and this court ordered remand to the trial court, at which point Mr. Harris asked the court to stay that order on the payment of cash until the hearing was determined. And Chancellor Moyers denied the order, so Mr. Harris was required to pay the money. And finally, Ms. Harris dissipated assets of the marital estate to the tune of $39,000. That equals $400,000, Your Honor. And I submit that that should be what Ms. Harris takes as an equitable division of marital property. And alternatively, though, pursuant to the Fox v. Fox case, which is discussed in the appellant's brief, an equitable division of the marital estate would be 75% to Mr. Harris and 25% to Ms. Harris. And I'll explain why I think that's equitable later by referencing the holding in that Fox case. And when it is claimed that the trial court erred in equitably dividing marital property, it was held in Jolly v. Jolly that this court's role is to determine whether the trial court applied the correct legal standards, whether the manner in which the trial court weighed the factors in 36.4.121C is consistent with logic and reason, and whether the trial court's division of marital property is, in fact, equitable. In this case, I respectfully submit, Your Honors, that that endeavor should result in a demonstrably different division of the marital property. Now, apropos to that end is that a division of marital property is not rendered inequitable simply because it is not precisely equal. In this case, the trial court said that the equitable division should be 50-50, and obviously we disagree with that. The fairness of the trial court's approach, according to the Altman decision, is inevitably reflected in its results. Now, let's turn to analyzing the facts of this case against the backdrop of the factors that are set out in the statute 36.4.121C. Factor 1 is the duration of the marriage, which in this case was 22 years, although the last 2 years Ms. Harris did not live with her husband. Subsection 2 speaks to the age, physical and mental health, vocational skills, employability, earning capacity, estate, and the financial liabilities and financial needs of the parties. Mr. Harris is almost 80. Ms. Harris is 26 years younger. Mr. Harris has leukemia and multiple myeloma, but is cognitively sharp. The record does not reflect that Ms. Harris has any physical or mental health issues. Mr. Harris possesses numerous skills, but is unable to work any longer because of his age and the diseases from which he suffers. Ms. Harris served as the office manager for Bent Tree Farms for many years, and then she leased and operated the business when Mr. Harris retired. And she's currently employed, or she was at the time of the hearing, by Ingalls. Mr. Harris is no longer employable while she is currently employed, and Mr. Harris no longer possesses any earning capacity, while Ms. Harris obviously does. As I mentioned earlier, she has already received a cash payment in this case of $152,500, and the proof is that she dissipated the estate in the amount of at least $39,000. Mr. Harris receives approximately $2,000 a month in Social Security benefits. Ms. Harris lives with her father in his home, and Mr. Harris lives on the Callahan Road property and must pay for its maintenance and all property taxes. Factor 3 is the tangible or intangible contribution by one party to the education, training, or increased earning power of the other party. Mr. Harris was already educated and a business owner when he met Ms. Harris. On the other hand, he did provide Ms. Harris new opportunities to learn how a business operates and to experience new opportunities in that regard by serving as the office manager and then later managing the business herself under lease after he retired. Subsection 4 requires a court to weigh the relative ability of each party for future acquisitions of capital assets and income. This factor weighs heavily toward Mr. Harris receiving a larger portion of the marital estate. Mr. Harris has no future ability to acquire capital assets and income, again, as I mentioned earlier, because of his age and health. Conversely, Ms. Harris is still relatively young and in good health. Now, the factors set forth in subsection 5A, I think, are relatively equal between the parties, as Mr. Harris fulfilled the role of wage earner and Ms. Harris the role of homemaker, except that Ms. Harris played no role in the acquisition of assets and was guilty of dissipation of assets, which was another factor that's specifically referenced in subsection 5. Factor 6 is the value of the separate property of each party. Ms. Harris did receive, again, the $152,500 earlier in the proceeding. Mr. Harris was awarded 2 separate pieces of realty, an undeveloped farm property in Banner Springs, Fentress County, and a small house and lot here in Knox County. Both of those properties were Mr. Harris's separate property prior to the marriage. Factor 7 is the estate of each party at the time of the marriage. And as contained in the statement of facts, Mr. Harris brought a fairly substantial estate into the marriage, which included the Callahan Road property, which at the time of the marriage was valued at $653,000. Ms. Harris brought very little in assets into the marriage. Subsection 8 requires the court to examine the economic circumstances of each party at the time the division of property is to become effective. The circumstances of the parties has radically changed. Mr. Harris retains an interest in the Callahan Road property, though the extent of that interest is, of course, an issue before the court today. And he was awarded these 2 separate pieces of property, realty, that I mentioned earlier. Unfortunately, Mr. Harris is land poor in terms of owning real estate versus cash on hand. His cash has been eaten up by medical bills and supporting his children, and he cannot go back to work. The $225,000 to $250,000 estate left to him by his mother was consumed in construction of the residence on the Callahan Road property. And as stated earlier, Ms. Harris has been awarded cash during the pendency of this case, and it is cash, and then there was the dissipation of assets. Furthermore, she lives with her father and continues to work, so she should be flush with cash. And factor 9, Your Honor, I wanted to discuss that. It concerns the tax consequences associated with the sale of an asset. By dividing the marital estate 50-50 between the parties, the court is, in effect, forcing a sale of the Callahan Road property. If the Callahan Road property is sold in order to pay the judgment awarded to Ms. Harris in the amount of $438,108.03, and keep in mind that figure is reached by subtracting the $152,500 as a credit, then both Ms. Harris and Mr. Harris will be liable to pay capital gains tax. On the other hand, if Ms. Harris's award is based on her half of the increase in the contributory value of the Callahan Road property, there will be no tax liability. And that is because there is an exclusion of up to $250,000 in gain based on the sale or transfer of ownership in the principal residence. Counsel for the plaintiff.
Counsel, I mean, that property was also used for a business, wasn't it? Wasn't there a business on the property?
It was, Your Honor. It's a fairly good-sized tract of property that's located off of Clinton Highway, kind of across the street from where the Walmart is off Clinton Highway.
Counsel, you've used your time. You have your time for rebuttal.
Thank you, Your Honor.
We'll hear from the appellee.
Morning, Your Honors.
Morning.
Scott Sadak of the Knoxville Bar. May it please the court, on behalf of Kelly Harris, the appellee. This is not a difficult case. The appellate makes the arguments that, one, the distribution of the marital estate was not equitable. The second argument is that the trial court somehow limited the appellate's cross-examination and prevented the appellate from testifying on direct examination. And his third and final argument is that the trial court was emotionally abusive towards the appellate. I will take up each of those arguments seriatim. It's our opinion that the trial court properly classified the entire marital estate and made a fair and equitable distribution of the marital estate. As the court states in Brown versus Brown, trial courts have wide latitude in fashioning an equitable division of marital property. A trial court's decision must be guided by the factors set out in Tennessee Code Annotated 36-4-121C. But the decision is not a mechanical one and is not to be rendered inequitable because it is not precisely equal, or because both parties did not receive a share of each piece of property.
When you look at the value of the property of $653,000 starting off of his separate property, and the increased value, what about $400,000?
Yes, Your Honor. There were, throughout the pendency of this litigation, I believe there were at least 5 separate appraisals done on that property. One at the time of the marriage, a contributory value. Another one was done on the assets that were on the property for the business that was on the property. And then finally, the total value of the property on the date of the divorce in 2017, which was $1,070,000.
So the going-in value of his separate property is more than what the increased value of that separate property will be.
Correct, Your Honor. The court had options as to what it determined number one, whether or not the property was marital. Number two, what the value of the property was and how it should be distributed. And three, what that total number was. And the trial court had options regarding what that number was, and the trial court said that the wife should be entitled to 1/2 of the total value of the Callahan Road property at $1,070,000. And we do not believe that that was an error on the trial court's part. I would point out for Your Honors that Tennessee Code Annotated 36-4-121C does not require that the trial court consider all factors, but rather all relevant factors as to what the trial court deems in its discretion to be a relevant factor. We believe that in this case, the trial court properly considered all relevant factors as identified in TCA 36-4-121C. Counsel for appellant goes through each of those factors. I'm sure Your Honors are all familiar with those factors. I will not now recite them, but I will point out what the trial court said as it relates to each of those factors. Obviously, the first factor, Tennessee Code Annotated 36-4-121C1, goes towards the length of the marriage. This was a 22-year marriage, which by definition is a long-term marriage in the state of Tennessee. Next, in reasoning its opinion, the trial court begins a pattern of grouping together the next few classifications. Tennessee Code Annotated 36-4-121C 2 and 3. The trial court says in its ruling that neither party has any significant ongoing capacity to produce additional income or acquire additional capital assets at this stage without someone selling something else that they already own, and that the health of Mr. Harris is going to likely preclude any additional work for him. The trial court moves on under subsection C, numbers 4 and 5. The other factors that I find to be applicable in this case are the tangible and intangible contributions of the parties to the acquisition, preservation, appreciation, dissipation of the marital and separate properties, and the contribution of Miss Harris holding down the fort and being your girl Friday so that you could go out and do the more lucrative jobs for the first 10 years or so. The trial court moves on to subsection C, numbers 6 and 7. The estate of each of the parties at the time they married, which was a goose egg for Mrs. Harris and was already substantial for Mr. Harris, with the real estate he already owned and the business that he developed. The trial court ruled the stipulated value of the Callahan Road property at the time of the divorce was $1,070,000 and divided that amount equally between the parties. The trial court ruled that all of the accounts held by the parties at the time of the divorce had transmutated to marital accounts and ordered that those be divided equally between the parties. The court then went on to award Mr. Harris the lion's share of the joint personal property, an amount worth around $60,000. My client effectively got, I believe, one bedroom suite and a chest full of some blankets. It's clear from the record that the trial court properly considered all of the relevant factors in the statute, Tennessee Code Annotated 36-4-121C, in making its determination of an equitable division in this case. Therefore, we believe that the final decree of divorce, final judgment of divorce should be affirmed. Moving on to the argument that somehow the court limited the defendant's cross-examination or prevented the defendant from testifying on direct examination, I would rely on my brief and point out that the cross-examination, the husband's cross-examination of the wife, encompasses 130 pages of the transcript. My examination of the husband encompasses 118 pages of the transcript. There's no question that the husband had an absolute right to proceed pro se at trial. However, husband's lack of knowledge regarding trial practice does not entitle him to endless questioning of a witness, especially when most of his questioning had already been asked and answered. Husband was allowed to testify on direct exam and chose not to testify. At the conclusion of my case, the plaintiff's case in chief, the court asked me if I had any additional witnesses. The husband interrupted and said, "I have one." Thereafter, the husband called Miss Norma Taylor to testify. At the conclusion of Miss Taylor's testimony, the trial court asked the husband, "All right, what else? What else you got?" Husband replied, "That's all I had, Your Honor." At that very moment, he rested his case in chief and waived his direct examination. Because of those factors, we do not believe that the defendant was limited in cross-examination and not allowed to testify on direct examination, and the trial court's order should be affirmed. Finally, the trial court was not emotionally abusive towards the defendant. The husband was admonished twice by the trial court for his nonverbal outburst during the trial. Unfortunately, the written transcript does not adequately convey the disrespect that the husband was exhibiting in the courtroom during those two instances. Husband was twice questioned by the trial court regarding his claim that he could not afford an attorney. On the day of trial, the husband had at least $68,000 in various bank accounts. On the day of trial, the husband was the owner of over $1.5 million in real estate. Husband's claim that he could not fire an attorney were simply false, and the trial court took notice of that fact. For all of those foregoing reasons, the appellee would ask for the final judgment of divorce to be affirmed in all respects. Thank you for your time this morning. Does anyone have any questions?
I hear none. Thank you. Hear from the appellant rebuttal.
Your Honors, with all due respect, wide latitude in fashioning what is an equitable distribution of property does not mean that the court cannot or has the freedom to depart from the factors set out in the statute in terms of applying the evidence to those. I realize counsel believes that the court, and he's recited some instances that he claims exhibit that the court did just that. It's my contention, and I set it out in my brief, what the relevant factors were that were testified to a court as applied to each one of those. Now, counsel says, and I guess is implying that, well, the judge only has to consider the relevant factors, the implication being that not all of the factors were relevant. Well, I've gone through and cited evidence that applies to each one of the factors that I referenced, and so I do believe that they apply. Counsel says that he did not in any way limit my client's pro se examination. Well, I also cited in my brief where the judge specifically said to him, "You've got 15 minutes. Do you understand? 15 minutes is 15 minutes." And he said, if you're not through in 15 minutes, you're through in 15 minutes.
What release are you requesting as a result of that?
I'm requesting, Your Honor, well, if the court does not, and I think the court has the factors, the facts before it necessary to modify the order and the equitable distribution of marital property, but if you do not think that that is proper, then I request a new hearing based on the conduct of the trial court in that regard.
You made this request in your brief?
I'm sorry, Your Honor.
You made this request in your brief?
Well, I say that it appears that it rendered the hearing suspect and unfair. I don't believe I did specifically say if I don't get a modification of the distribution of property that you should remand, and that's on me. But that's what I intended to suggest when I said that. And I also would like to say that I was attempting, and maybe I should not have, but I was attempting to not go too far in my criticism of the trial court, Your Honor. Now, counsel said that...
Counsel, you've used your time.
Thank you, Your Honors.
Our thanks to both of you. We appreciate your argument this morning and your briefs on this. Recess court till 1:30 this afternoon, please.
All rise. This court is now in recess until 1:30.